of really painful stories in Minnesota, and similar stories could be told from across the country. I even agree with parts of her criticism of the mismanagement of COVID by Washington, D.C. I don't know what any of that has to do with what we're here to do today. Huge parts of what we're doing in this hearing would be really confusing to eighth graders. If civics classes across the country tuned into this hearing and tried to figure out what we're here to do, and they heard as much as they've heard about 2009 Finance Committee debates about what should be in a healthcare reform package. I'm blessed to sit not just on the Judiciary Committee, but also on the Finance Committee. And lots of the discussions we've had in here today fit better in a Finance Committee hearing than in a Judiciary Committee hearing. So I think it would be very useful for us to pause and remind ourselves and do some of our civic duty to eighth graders to help them realize what a president runs for, what a senator runs for, and on the other hand, why Judge Barrett is sitting before us today, and what the job is that you're being evaluated for. So if we can back up and do a little bit of eighth grade civics, I think it would benefit us and benefit the watching country, and especially watching eighth grade civics classes. So I'd like to distinguish first between civics and politics, because there was a time, the chairman said at the beginning of this hearing, there was a time when people that would be as different as Ruth Bader Ginsburg, and she was a heroic woman, that's absolutely true, and Antonin Scalia, another brilliant mind and your mentor, people that different could both go through the Senate and get confirmation votes of 95 or 98 votes. And the chairman said at the beginning of the hearing, he doesn't know what happened between then and now. I think some of what happened between then and now is we decided to forget what civics are and allow politics to swallow everything. So if I can start, I'd like to just remind us of the distinction between civics and politics. Civics is the stuff we're all supposed to agree on, regardless of our policy views differences. Civics is another way we talk about the rules of the road. Civics 101 is the stuff like Congress writes laws. The executive branch enforces laws. Courts apply them. None of that stuff should be different if you're a Republican or a Democrat or a Libertarian or a Green Party member. This is basic civics. Civics is the stuff that all Americans should agree on, like religious liberty is essential. People should be able to fire the folks who write the laws, and the voters can't fire the judges. Judges should be impartial. This is just civics 101. Politics is different. Politics is the stuff that happens underneath civics. Civics is the overarching stuff we as Americans agree in common. Politics is the subordinate, less important stuff that we differ about. Politics is like if I look at my friend Chris Coons and I say, listen up, Jackwagon, what you want to do on this particular finance committee bill is going to be way too expensive and might bankrupt our kids. Or if Chris looks back at me and says, listen up, Jackwagon, you're too much of a cheapskate and you're underinvesting in the next generation. That's a really important debate. That's a political debate. That's not civics. Civics is more important than that. Civics doesn't change every 18 to 24 months because the electoral winds change and because polling changes. I think it's important that we help our kids understand that politics is the legitimate stuff we fight about, and civics is the places where we pull back and say, wait a minute, we have things that are in common, and before we fight again about politics, let's reaffirm some of our civics. So I'd like to have just sort of a basic grammar of civics for 5 minutes. One thing that we should all agree on and two things that we should all disagree with. We should agree on it, but one thing that we agree about and are in favor of, and two things that we agree on that we should all reject. First, a positive, grand, unifying truth about America, and that is religious liberty. Religious liberty is the basic idea that how you worship is none of the government's business. Government can wage wars, government can write parking tickets, but government cannot save souls. Government's really important. War is important. Parking tickets are important. But your soul is something that the government can't touch. So whether you worship in a mosque or a synagogue or a church, your faith or your lack of faith is none of the government's business. It's your business and your families and your neighbors and all sorts of places where people break bread together and argue. But it's not about power. It's not about force. It's not about the government. This is the fundamental American belief. Religious liberty is one of those 5 great freedoms clustered in the First Amendment. Religion, speech, press, assembly, and protest, these 5 freedoms that hang together, that are the basic pre-governmental rights, are sort of civics 101 that we all agree on well before we ever get to anything as relatively inconsequential as tax policy. So civics should be the stuff we affirm together. And contrary to the belief of some activists, religious liberty is not an exception. You don't need the government's permission to have religious liberty. Religious liberty is the default assumption of our entire system. And because religious liberty is the fundamental 101 rule in American life, we don't have religious tests. This committee isn't in the business of deciding whether the dogma lives too loudly within someone. This committee isn't in the business of deciding which religious beliefs are good and which religious beliefs are bad and which religious beliefs are weird. And I just want to say, as somebody who's self-consciously a Christian, we got a whole bunch more really weird beliefs. Forgiveness of sins, the virgin birth, resurrection from the dead, eternal life. There are a whole bunch of really, really crazy ideas that are a lot weirder than some Catholic moms giving each other advice about parenting. And yet there are places where this committee has acted like it's the job of the committee to delve into people's religious communities. That's nuts. That's a violation of our basic civics. That's a violation of what all of us believe together. This is not a Republican idea. It is not a Democrat idea. It's a Democrat idea and a Republican idea, but more fundamentally, it's an American idea. And the good news is, whether you think your religious beliefs might be judged wacky by someone else, it's none of the business of this committee to delve into any of that in this context, because in this committee and in this Congress and in this constitutional structure, religious liberty is the basic truth. And whatever you or I or Judge Barrett believe about God isn't any of the government's business. We can all believe in that in common. We should all reaffirm that in common, and that should be on display over the course of the next 4 days in this committee. Now, a couple of terms that all of our 8th graders should know as things we should reject in common. And again, shared rejection, not Republican versus Democrat or Democrat versus Republican, but a shared American rejection. And the first is this: judicial activism. Judicial activism is the idea that judges get to advocate for or advance policies, even though they don't have to stand for election before the voters, and even though they have lifetime tenure. Judicial activism is the really bad idea that tries to convince the American people to view the judiciary as a block of progressive votes and conservative votes, Republican justices and Democratic justices. This is the confused idea that the Supreme Court is just another arena for politics. When politicians try to demand that judicial nominees, who are supposed to be fair and impartial, when politicians try to get judicial nominees to give their views on cases or to give their views on policies, to try to get them to pre-commit to certain outcomes in future court cases, we are politicizing the courts, and that is wrong. That is a violation of our oath to the Constitution. Likewise, when politicians refuse to give answers to the pretty basic question of whether or not they want to try to change the number of justices in the court, which is what court packing actually is, when they want to try to change the outcome of what courts do in the future by trying to change the size and composition of the court, that is a bad idea that politicizes the judiciary and reduces public trust. On the other hand, depoliticizing the court looks a lot like letting courts and judges do their jobs and the Congress do our jobs. You don't like the policies in America? Great, elect different people in the House and in the Senate and in the presidency. Fire the politicians at the next election. But voters don't have the freedom to fire the judges. Therefore, we should not view judges, and we should not encourage judges or the public to view them as ultimately politicians who hide behind their robes. The antidote to judicial activism is originalism. Originalism, also known as textualism, is basically the old idea from 8th grade civics that judges don't get to make laws. Judges just apply them. An originalist comes to the court with a fundamental humility and modesty about what the job is that they're there to do. An originalist doesn't think of herself as a super legislator whose opinions will be read by angels from stone tablets in heaven. Judicial activism, on the other hand, is the bad idea that judges' black robes are just fake, and truthfully, they're wearing red or blue partisan jerseys under there. We should reject all such judges. And so today, when we have a nominee before us, We should be asking her questions that are not about trying to predetermine how certain cases will be judged. And a final term that we should be clear about, I mentioned earlier, but I think it's worth underscoring, is we should underscore what is court packing. Court packing is the idea that we should blow up our shared civics, that we should end the deliberative structure of the Senate by making it just another majoritarian body for the purposes of packing the Supreme Court. Court packing would depend on the destruction of the full debate here in the Senate, and it is a partisan suicide bombing that would end the deliberative structure of the United States Senate and make this job less interesting for all 100 of us, not for 47 or 53, because it's hard to get to a supermajority that tries to protect the American people from 51, 49, 49, 51 swings all the time. What blowing up the filibuster would ultimately do is try to turn the Supreme Court into the ultimate super legislature. Court packing is not judicial reform, as some of you who wrote the memo over the weekend got a lot of media to bite on. Court packing is destroying the system we have now. It is not reforming the system we have now. And anybody who uses that the language that implies filling legitimate vacancies is actually just another form of court packing that's playing the American people for fools. And the American people actually want a Washington, D.C. that depoliticizes more decisions, not politicizes more decisions. So, Judge, I'm glad that you're before us. I'm looking forward to hearing your opening statement later today, and I look forward to the questioning you have to endure over the next 2 or 3 days, even though you probably look forward to it a little bit less. Congratulations and welcome.
Senator Coons.
Thank you, Mr. Chairman. Judge Barrett, to you and your family, welcome. Over the past weeks, I've been flooded with calls, texts, emails from Delawareans. Delawareans who are scared because they are worried about their own health, the health of a parent or child, because they don't know if it's safe for their kids to go to school, if their businesses will survive, or because they're wondering why on earth this Senate is focused on racing forward with a Supreme Court nominee, but is not willing to take a vote to provide needed relief for them and their families. It is an understandable question when we're in the midst of a devastating global pandemic in which more than 210,000 Americans have died, more than 7 million have been infected and have a new pre-existing condition, why there were just 300,000 new cases this week. And today, more than 25 million Americans are collecting unemployment. This is an ongoing national emergency, and as an exercise in civics, not politics, we in Congress should be working day and night to deliver them that relief. Instead, my colleagues are barreling forward with a confirmation hearing that's distracting from our responsibility to our constituents and threatens to further tear our nation apart. Mr. Chairman, as you know, we're just 22 days from an election. There is no precedent, despite my colleagues' lengthy and I think hypocritical lecture about the history. There is no precedent in our nation's history for confirming a Supreme Court nominee by the Senate this close to a presidential election, in which a majority of states are already voting. In fact, 6 million Americans have voted. This process flies in the face of the very rule Republicans set themselves in 2016, when they refused, as a matter of politics, not of civics, to even consider a highly qualified nominee, Judge Merrick Garland, 9 months before an election, simply because it was an election year. And Mr. Chairman, in 2018, you went a step further and said, if an opening on the Supreme Court came up in the last year of President Trump's term, you would wait until the next election and let the voters decide. So what changed? Sadly, nothing. Nothing except the fact that this time, President Trump and his allies in the Senate saw a chance in Justice Ginsburg's untimely passing to shift the balance of the Supreme Court for decades to come, and that will have consequences in the real lives of millions of Americans. Proceeding with this confirmation today is wrong. And if I could, to my colleague who just spoke, religious liberty, I agree, is foundational to our civics and our republic. And I and my colleagues will focus, Judge Barrett, on your legal writings, your opinions, your articles, your speeches as a law professor and judge. And I think when we do that, we will conclude the ways in which you may serve as a justice will do irreparable harm. I think proceeding with this nomination in this way at this time will also do harm to what remaining trust we have in each other, to the Senate as a whole, and potentially to the court itself. As if all of this weren't reason enough for us to delay, we're proceeding despite having 2 members of this committee who've contracted the virus. That's why the Senate's out of session today. That's why all of us, when not speaking, are wearing masks. That's why the distance between us. In light of all of this, in light of the stresses on our country, I think this rushed, hypocritical, partisan process should not proceed. But instead we are. So let me try and help explain to those who've reached out to me why and why it matters. Centrally, it's this. President Trump has promised over and over and over again that he would repeal the Affordable Care Act. He ran on that promise, but despite his very best efforts, he's failed. My Republican colleagues here and in the House have voted over and over and over to repeal the Affordable Care Act since it was passed a decade ago. But thankfully for the people of our nation and my state, they too have been unsuccessful. And yet today, to make good on this promise to achieve what they could not accomplish through the democratic process, they're looking to the courts, in fact, to the court. They're looking to this nominee. President Trump explicitly promised anyone he nominated to the Supreme Court would do the right thing and be a vote to overturn the Affordable Care Act. And just 1 week after the upcoming election, the Supreme Court will hear a case in which the Affordable Care Act is at issue and where the Supreme Court will hear argument that supports the Trump administration and the Trump's Department of Justice position to strike down this landmark law. So let me be clear. Just a week after the upcoming election, the Trump administration will be telling the Supreme Court to tear down the very law that provides healthcare protections in the middle of an ongoing pandemic. Judge Barrett, you've publicly criticized the Supreme Court's past decisions upholding the Affordable Care Act, and I think that is appropriately at issue in the days to come. The president knows this, and it's one reason why he and my colleagues are rushing to have this confirmation just in time to hear the administration's challenge to the Affordable Care Act. I don't think this is a coincidence. It's beyond ironic that this administration, which has failed to respond to this pandemic, is rushing through a judge they believe will vote to strip away healthcare protections. Today, because of the Affordable Care Act, insurance companies cannot discriminate against women for being women. They cannot charge more. They cannot treat pregnancy as a pre-existing condition. I cannot think of a sharper irony as we consider the legacy of Justice Ginsburg, who dedicated her life to fighting for gender equality. It also prevents insurance companies from charging any with pre-existing conditions more, so Americans no longer have to worry about going bankrupt because of an unexpected illness or accident. Don't take my word for it. Listen to the voice of Carrie, who's behind me to my right. Carrie from Middletown, Delaware, used to pay $800 a month for junk insurance, as she called it. Coverage so skimpy, she had to live in fear of going to the doctor's office or needing medication. Because of the ACA, she was able to get better coverage to pay what she can afford based on her income. She has diabetes, she has high blood pressure, but thanks to the ACA, she can't be denied care or coverage. She told me when he spoke, this takes the stress and the worry out of it, and then asked me, how is this even at issue? Wasn't that settled years ago? Carrie's right. She should have the peace of mind that you can care for yourself and your family if you get sick. I've heard so many more stories from Delaware. Just over my shoulder here is Debbie from Newcastle, a self-employed small business owner who receives her health insurance through the marketplace. Her pre-existing condition requires her to attend physical therapy and doctor's appointments multiple times each month. Without the ACA, insurance companies would have charged her more because of her condition, and she wouldn't be able to afford her medical bills and support her small business. There's Barb Slater from Newark, Delaware, who was diagnosed with scleroderma 4 years ago. After losing her employer-sponsored health insurance, she was able to find new coverage in the marketplace thanks to the Affordable Care Act. My inbox and the inbox of all my colleagues are filled with stories like Carrie's, Debbie's, Barb's, and they highlight the breadth of what the ACA means to the American people. The ability of young people to stay on their family's insurance, lower out-of-pocket costs for seniors' prescriptions, the elimination of lifetime caps. These protections are on the line in the ballot and on the docket of the Supreme Court. And it's not just the ACA at risk. Judge, I'm deeply concerned about ways in which your approach to something that may sound abstract to folks watching stare decisis or precedent, that means your approach to reviewing and reconsidering and possibly overturning long settled cases may overturn some of the very principles for which Justice Ginsburg fought her entire adult life, principles that protect settled fundamental rights for all Americans. What might this mean? Cases like Griswold versus Connecticut that establish married couples have a right to obtain and use contraception in the privacy of their own home may be in danger of being struck down. It means cases like Roe versus Wade, which protects a woman's right to make her own critical healthcare decisions, may be on the line. And it means Obergefell versus Hodges, which made marriage equality the law of this land, could be overruled just a day after we celebrated Coming Out Day nationally, stripping LGBTQ individuals of what Justice Kennedy memorably called equal dignity in the eyes of the law. This is what I believe is at stake with this nomination. Judge Barrett, you will be deciding cases that have real daily impacts on the lives of millions of Americans. They deserve to understand why President Trump nominated you and what consequences your decisions may have on them and their lives. I've heard my Republican colleagues say all they care about is finding a future justice who will apply the law as written, as if all this is about today is an abstract fight about interpretive methodology and jurisprudence. They seem shocked we're talking about what the Supreme Court might do if Judge Barrett were to become Justice Barrett. But Judge Barrett, I'm not suggesting you made some secret deal with President Trump, but I believe the reason you were chosen is precisely because your judicial philosophy, as repeatedly stated, could lead to the outcomes President Trump has sought. And I think that has dramatic and potentially very harmful consequences with regards to the election, the Affordable Care Act, and long settled rights. This is what I intend to lay out this week. And this is what I hope the American people will hear in the course of this confirmation hearing. Thank you, Mr. Chairman.
Thanks, Senator Coons. For planning purposes, I think I talked to Senator Feinstein. We will go to Senator Hawley, Blumenthal, and Tillis. We'll take a 30-minute break to grab a bite to eat and take a little bit of a break and come back and finish up. So, Senator Hawley.
Thank you, Mr. Chairman. Judge Barrett, welcome. It's good to see you again. Jesse Barrett, welcome, and to you and to your family as well. I see that some of your children are getting a break. They've earned it, I think. I'm amazed as I've been watching. I've got two little boys at home, my wife and I do. I can't believe how calmly your children have been sitting for a couple of hours. So maybe you can give me some tips, Jesse and Judge, when we're finished here. You know, we've gotten to read a lot about your family in the last few weeks. We've gotten to read a lot about you in the press, and in particular about your religious beliefs. One attack after another in the liberal media, one hit piece after another, many of them echoed by members of this committee, like this one, for instance, Barrett, long active with Insular Christian Group. We've read stories about your Catholic lifestyle, stories about how you raise your children, stories about how you adopted your children, stories about your Catholic doctrinal beliefs, over and over and over questioning whether you have, I guess, the independence to be a judge, a justice on the United States Supreme Court. And it's not just in the newspapers, it's members of this committee, including the Democratic nominee for Vice President of the United States, who has questioned past nominees who have come before this committee about their membership in Catholic fraternal organizations like the Knights of Columbus. And for those watching at home, that's right, you heard me correctly. Senator Harris and others on this committee have repeatedly questioned judicial nominees' fitness for office because of their membership in the Knights of Columbus. The ranking member, when you were last before this committee, Judge, for your initial confirmation hearings, the ranking member referred to your Catholic convictions as dogma, that's a quote, that lives loudly within you, picking up the very terminology of anti-Catholic bigotry current in this country a century ago. She wasn't alone. Other senators on this committee last time asked you if you were an Orthodox Catholic. One senator said she worried that you would be a Catholic judge if you were confirmed because of your religious beliefs, I guess as opposed to an American judge, as if you can't be both a devout Catholic and a loyal American citizen. And it's not just you, Judge. Other nominees who have come before this committee for years now have been asked by my Democrat colleagues over and over their views on sin, their views on the afterlife, their views about their membership statements of Catholic organizations, about their membership in other Christian organizations, and on and on and on. And let's be clear about what this is. This is an attempt to broach a new frontier, to set up a new standard. Actually, it's an attempt to bring back an old standard that the Constitution of the United States explicitly forbids. I'm talking about a religious test for office. Article 6 of the Constitution of the United States, before we even get to the Bill of Rights, Article 6 of the Constitution of the United States says clearly, and I quote, "No religious test shall ever be required as a qualification to any office or public trust under the United States." Now, that was big news in 1787 when it was written, and it's worth remembering why. It's because no country, no republic in the history of the world had ever guaranteed to its citizens the right to freedom of conscience and religious liberty. Every other country that had ever existed tied together the religious beliefs that would be approved by the powerful and the right to serve in office or to vote or just to be a citizen. In every other country across history, you had to agree with what those in power agreed with in order to hold office or be a citizen in good standing. You had to sign a particular religious confession, or you had to disavow a particular religious group, swear not to follow the Pope, for instance. You had to pledge allegiance to the God of the city or the God of the empire. This was true from 18th century Britain all the way back to ancient Rome. And so when our founders put Article 6 into the Constitution of the United States, they were making a very deliberate choice. They were breaking with all of that past history, and they were saying in America, it would be different. In the United States of America, we would not allow the ruling class to have veto power over your faith, over what Americans believed, over who we gathered with to worship and why and where and how. No, in this country, the people of the United States would be free to follow their own religious convictions, free to worship, free to exercise their religion, and people of faith would be welcome in the public sphere. They'd be welcome there. They'd be welcome without having to get the approval of those in power, like those on this committee. They would be welcome to come and to bring their religious beliefs to bear on their lives, on their office, and all that they do. So long, of course, as they were peaceful citizens who followed the law. Religious people of all backgrounds would be welcome in public life. And no person in power would be able to control what the American people, any American citizen, thought or believed or who they worshiped. This freedom of conscience and religious liberty undergirds all of our other rights because it tells the government that it cannot tell us what to think or who we can assemble with or how we can worship or what we can say. And that's why Article 6 is there even before we get to the Bill of Rights and the First Amendment. But this bedrock principle of American liberty is now under attack. That is what is at stake when we read these stories attacking Judge Barrett for her faith. That is what is at stake when my Democratic colleagues repeatedly question Judge Barrett and many other judicial nominees about their religious beliefs, about their religious membership, about their religious practices, about their family beliefs and practices. That is an attempt to bring back the days of the religious test. That is an attempt to bring back the veto power of the powerful over the religious beliefs and sincerely held convictions of the American people. And that is what is at stake in this confirmation hearing. Judge Barrett is a Catholic. We all know that. She's a devout Catholic. We all know that. She and her husband have chosen to raise their family according to their Catholic beliefs in faithful fellowship with other Catholics. We all know that. Heck, 65 million Americans are Catholics, and many millions more are Christians of other persuasions. Are they to be told that they cannot serve in public office, that they are not welcome in the public sphere unless the members of this committee sign off on their religious beliefs? I, for one, do not want to live in such an America. and the Constitution of the United States flatly prohibits it. Now, the Constitution says that people of faith, like Judge Barrett, are welcome in high office, welcome in any office, welcome throughout our public life here in this country. And I would just say to my Democrat colleagues that these years now, this pattern and practice, as we say in the law, this pattern and practice of religious bigotry, because that's what it is. When you tell somebody that they're too Catholic to be on the bench, when you tell them they're going to be a Catholic judge, not an American judge, that's bigotry. The pattern and practice of bigotry from members of this committee must stop. And I would expect that it be renounced. Now, I just heard my colleague, Senator Coons, make a reference to an old case, the Griswold case, which I can only assume is another hit at Judge Barrett's religious faith, referring to Catholic doctrinal beliefs. I don't know what else it could be, since no one has challenged this case. It's not a live issue and hasn't been for decades. This is the kind of thing I'm talking about, and this is the sort of attacks that must stop. I look forward, Judge Barrett, to getting to the chance to speak with you further about your legal credentials, about your legal views, about your approach to the law and your judicial philosophy. But I hope that one thing that this confirmation process will stand for in the end, I hope when we look back at the confirmation hearings for Judge Amy Barrett, soon I hope to be Justice Amy Barrett, one thing we will say is that was the time, that was the year that the attempt to bring back religious tests for office was finally stopped. Thank you, Mr. Chairman.
Senator Blumenthal.
Thank you, Mr. Chairman. Judge Barrett, and to your family, welcome to the committee. I want to introduce you to one of my constituents, Connor Kern of Ridgefield, Connecticut. He is 10 years old and he suffers from Duchenne muscular dystrophy. It is a horrible, incurable disease. It slowly deprives children of the strength and their ability to move. Eventually, it robs them of their lives. The costs of providing Connor's care are astronomical, but for Connor and his family, it is worth every penny. Connor is a superhero, but he's always had a real sidekick. He's had the protection of the Affordable Care Act. It has shielded him and his family from arbitrary caps on coverage that would have cut off his care when it became too expensive. It has protected Connor from losing insurance because of this insidious disease that he never caused and chose. The Affordable Care Act has given his family a measure of relief, of hope, of peace. They still worry about Connor's health, but not their coverage or its costs. Connor and millions of others like him are why I will oppose your nomination. Your nomination is about the Republican goal of repealing the Affordable Care Act, the Obamacare they seem to detest so much. It's about people like Connor, protections for people with pre-existing conditions, tax credits that make health insurance more affordable, bans on charging women more simply because they are women. That's what my Republican colleagues have been fighting to repeal for the last decade. They voted dozens and dozens of times to repeal the Affordable Care Act, and they have challenged it twice unsuccessfully in the United States Supreme Court. And each time they failed. But now, just 1 week after the election, as you know, the fate of the Affordable Care Act will be again in the hands of the United States Supreme Court. Republicans have turned again to the court to try to achieve judicially what they cannot achieve legislatively. President Trump has vowed that any judge he nominated would pass the very strong test, his words, and that they would strike down the Affordable Care Act. Judge Barrett, in all honesty, you have auditioned for this job through your academic writing and judicial opinions, and you've passed that test. In fact, you've stated twice in effect that you would have voted to strike down the Affordable Care Act had you been a justice at the time. You've been vetted, you've been screened by the Trump administration and special interests who want an activist judge. They want someone who will legislate from the bench and strike down laws supported by a vast majority of the American people. And that activism uses originalism as a smokescreen. If the American people have any doubts about how dedicated my Republican colleagues are to taking away people's health care, just listen to their own words. They've been remarkably candid and forthright. Senator Graham, our chairman, has said, "You can't repair this monstrosity," I'm quoting, "you can't repair this monstrosity called Obamacare. You have to tear it down and start over." Senator Ernst has said, quote, "I support immediate action to repeal Obamacare and replace it." Senator Cornyn, "It's time to repeal and replace." Senator Tillis, "Repeal Obamacare. Let's end this disaster." And President Trump himself has said, "We want to terminate Obamacare." Millions of Americans, more than 130 million, have a pre-existing condition: asthma, heart disease, diabetes, cancer, Parkinson's, pregnancy, and now, by the cruelest of ironies, COVID-19. COVID-19, the cause of this pandemic, now is a pre-existing condition that could prevent millions of Americans from being covered by health care. Stripping health care from millions of Americans during a pandemic, that's really what is at stake in the Republican lawsuit, now before the Supreme Court, and in this nomination. And sadly, it's not just the Affordable Care Act that's at stake. It's a woman's right to decide when and how to have a family, control over her own body. An activist judge on the bench doing what Congress could not do would also strike down common sense gun safety laws. Connecticut has been at the forefront on gun violence protection. On gun safety, Judge, you acknowledged that your dissenting opinion in Canner sounds kind of radical. That's because it is. But if your views on the Second Amendment are adopted by the Supreme Court, it would imperil common sense state laws like Connecticut's all around the country. Today, we ought to be working on improving American health care. We ought to be fighting COVID-19, which has infected 8 million Americans and killed more than 215,000. We should be producing a national testing strategy, instituting effective contact tracing, and securing sufficient PPE. We ought to be providing assistance to the millions of Americans who have lost their job and heartbreak. President Trump has failed to do any of it. Instead, he and our Republican colleagues are riveted on rushing a judge through this sham process, dropping everything else. President Trump's failure to act will likely lead to 55,000 additional deaths, 55,000 additional Americans lost over just the next 3 months. Senate Republicans are refusing to address American health care or COVID-19 or economic relief because they care more about putting an extremist ideological judge on the bench and not just on the Supreme Court. I've learned as a senator that there are very few unwritten rules, very few written rules, I should say, in this place. But there is one very important unwritten rule. Keep your word. Republicans have all sorts of excuses for why they are breaking their promise, the promise that they would not confirm a Supreme Court justice during an election year. Each excuse boils down to nothing more than raw political power. They're doing it because they can. But might does not make right. They have boasted they have the votes, but they don't have the American people and they don't have history on their side. The American people want a plan to fight and conquer this disease. They want a plan to put Americans back to work. They want a blueprint for the future, not rolling back rights and turning back the clock. I revere the Supreme Court. I clerked for Justice Harry Blackmun. I've argued cases before the court 4 times. Now I'm really deeply concerned that the Supreme Court is losing the trust and respect of the American people. The authority of the Supreme Court depends on that trust. It has no army or police force to enforce its decisions. The American people follow the Supreme Court's commands, even when they disagree, because they respect its authority. And now, President Trump and the Republican Senate are eroding, indeed destroying, that legitimacy. They've stripped the American people of their say in this process simply to confirm a justice who will strike down in court, legislate from the bench, what they can't repeal in Congress. Your participation, let me be very blunt, in any case involving Donald Trump's election would immediately do explosive, enduring harm to the court's legitimacy and to your own credibility. You must recuse yourself. The American people are afraid and they're angry, and for good reason. It's a break the glass moment. Americans must use their voices to speak out and stand up, to contact my colleagues on this committee, despite their boasts about having the votes. Stand up and speak out to protect their own health, public health, and the health of our democracy. Thank you, Mr. Chairman.
Thank you, Senator Blumenthal. We will now have Senator Tillis, who's with us remotely. After his opening statement, we will come back at 12:20. And Senator Hirono, you will be the first one to make a statement. So Senator Tillis.
Thank you, Chairman Graham and Ranking Member Feinstein. I want to take a moment to honor the life and legacy of Justice Ginsburg. She was a living legend and a giant in the legal world as a professor, as a lawyer, and as a judge and a justice. She was an inspirational model and role model, and we honor her legacy. And I just want to make sure that her family knows the nation mourns her loss. But today we're here to consider nomination of a highly qualified jurist to the United States Supreme Court, Judge Amy Coney Barrett. She's a top legal scholar, a professor in the mold of the late Justice Scalia. Her work is widely respected in the legal community, and it's clear why her former students voted her multiple times to be the Distinguished Professor of the Year at the Notre Dame Law School. It's also why every full-time faculty member of Notre Dame Law supports her nomination. Her legal work and teaching have inspired hundreds of young lawyers, especially aspiring female lawyers. She's a remarkable mother. She has 7 beautiful children, and in spite of being busy working as a Seventh Circuit Justice, she makes time to be involved in her community. And this nomination is important because it's going to have a lasting impact on our republic. A justice service on the bench involves every important issue facing our constitutional republic. What are the limits of abusive and intrusive government power? What's the proper role of each branch of government? And what are the fundamental protections that our Constitution grants all Americans? These are foundational questions for the Supreme Court, and they consider them every single term. If confirmed, Judge Barrett will be tasked with answering these questions, and I believe she's going to do a great job. But it's not the rights enshrined in the Constitution that's most important. It's the structure of the document itself that ensures our freedom. Justice Scalia understood this. He was fond of saying, every dictator in the world, every president for life has a Bill of Rights. That's not what makes us free. What makes us free is our Constitution. Think of the word Constitution. It means structure. Justice Scalia went on to note the genius of our founding generation is that it dispersed power across multiple departments. The real danger to our constitutional republic is centralization of power in any one part of government. When that happens, liberty dies and tyranny reigns. That's why it's critical that Supreme Court justices maintain the proper role. They decide cases, they don't make policy. In recent decades, the court has drifted towards a trend where it decides majority disputes over policy rather than reserving those decisions for the American people through acting through their elected representatives, people like those of us in the U.S. Senate. Article 3 judges cannot and should not be policymakers. We've heard many speak today about policy priorities that they'd like an activist court to pass. Several of my colleagues have engaged in fear-mongering and described Judge Barrett's nomination as an end to health care, abortion rights, labor rights, and the list goes on and on and on. These statements are unfair and they're untrue. This week, they'll attempt to have Judge Barrett commit to policy outcomes rather than do the work for that policy outcome in the U.S. Senate. Just last month, while they were falsely claiming Judge Barrett's nomination would bring an end to the protections for pre-existing conditions, every single Democrat on this committee voted against a measure that would do just that. They're failing to do their job, and they want the court to do it for them. My review of Judge Barrett's record convinces me she's not only one of the most qualified individuals ever to be nominated, but she also understands the proper role of the Article 3 branch. She reaches conclusions dictated by the law, not by personal preference. That's the right thing to do. My Democratic friends decry the idea a nominee has predetermined outcome in mind, while in the same breath, they demand the nominee agree to their preferred outcome of a case. The hypocrisy is incredible. They ignore a central fact. Judge Barrett's rulings aren't meant to be for or against a particular policy outcome. She's not a legislator. That's our job. However, when the minority can't get their bad policies passed in Congress, they turn to the courts to demand that judges interpret the law not as written, but as they prefer. Her opinions simply order the outcome the law dictates. As passed by Congress, a politically accountable branch, nothing more and nothing less. My Democratic colleagues claim they care about the First Amendment, the Fifth Amendment, the 14th Amendment. If they care about our constitutional liberties, then they should care about confirming a judge who understands the proper role of the Supreme Court. Rights granted by none can just as easily be ended by none. To quote Justice Ginsburg, real change, enduring change, happens one step at a time. It doesn't happen by judicial fiat. Judge Barrett understands that principle. She knows the role of the Supreme Court justice, and she is highly qualified to do this job. Judge Barrett, when I met with you in the Capitol, I asked you to sign 2 pocket constitutions for my 2 granddaughters, and in it, you wrote, dream big. When they're old enough to understand the significance, I'm going to explain to them that just like Justice Barrett, they can, with hard work and determination, realize their American dream. So for the next few days, when members of this committee mischaracterize your views, their allies in the liberal media are saying terrible things about you and your family, stand tall, stand proud, and stand true. Rely on your faith. I know that you're an inspiration to millions of young women in this country, like my granddaughters, and we're proud of you. Thank you, Judge Barrett, for being with us today. Congratulations on the recognition of your hard work and your character. I look forward to hearing your testimony. Thank you, Mr. Chairman.
Thanks, Senator Tillis. We'll be in recess until 12:20. We'll start back with Senator Hirono.
And with that, the chairman of the Senate Judiciary Committee, Lindsey Graham, calls the committee to a break. He said about a half-hour break for what he called a short lunch. You see Judge Barrett walking out of the courtroom with her husband and perhaps several of their children. Some of the children left the hearing. There they are. I guess they came back in. We've been watching for the last 2.5 hours as the Senate Judiciary Committee in a tableau, a scene that we have never seen before, a Senate, or rather Supreme Court confirmation hearing with members of the Senate socially distanced themselves in their seats, a smaller number than usual of people in attendance, very few reporters, news reporters, but of course the judge who is the nominee herself seated there with her family behind her. They're taking a half-hour break. They will come back, and while we wait, we are going to be talking with our analysts. I'm Judy Woodruff in our NewsHour studio. We've been covering this from the beginning, and I want to turn to reintroduce our analysts. They are Marcia Coyle, who's a NewsHour regular, Victoria Nurse of Georgetown University. Earlier, she served as chief counsel to then Vice President Joe Biden and as counsel to the Senate Judiciary Committee when Joe Biden was its chairman. And Sai Krishna Prakash, he's a constitutional law scholar at the University of Virginia. He's a former clerk to Justice Clarence Thomas. And we should say that he's been contacted by the Judiciary Committee potentially about testifying on Thursday as a witness in favor of Judge Barrett's confirmation. So we thank all of you. And I'm going to turn to you first, Marcia Coyle. I was just saying this is a hearing like none we've seen before because we are in a pandemic, because there's social distancing. And yet the Democratic members of the committee, the Republican members of the committee, predictably came right out of the gate with their very strong positions for and against Judge Barrett.
Judy, I think the value of opening statements is really to just lay out the parameters of the questions and issues that are going to be coming up in the next 2 days. And I think on the Democratic side, those senators have been singularly focused on one, process. They're repeating over and over again that this is a rushed process and it's coming at a time when the Senate should be focused on coming up with an aid package for those suffering the consequences of the coronavirus. So we're hearing a lot about the timing. Also, they're really singularly focused on the Affordable Care Act and the fact that a week after the November election, the U.S. Supreme Court will be hearing a challenge brought by, I believe, about 18 Republican-led states that are urging the Supreme Court to find that what the Senate and the House did back in 2017 to that law made it unconstitutional, and the court should take down the entire law. So they're trying to make a case to the public about Justice Barrett going on the court and her vote in that case. On the Republican side, Judy, I'm hearing a lot about religious attack on this nominee, and the truth is, it seems as though Republicans are talking more about religion than the Democrats are. There have been articles about Judge Barrett's membership in this religious Catholic-related group called People of Praise, but I don't sense that the Democrats want to make a case out of her religion in the next 2 days at all. I think they're going to continue to press the potential of her vote in the Affordable Care Act, as well as several other areas in which she has written about certain legal issues that could come before the court very soon again, as well as any potential election consequences. And the Republicans, besides staking out religion, also, we heard that originalism is the antidote to judicial activism. And we know that Judge Barrett does consider herself an originalist. And so I expect that the Republicans are anticipating perhaps some Democratic questions or attacks on her approach to judging and her reliance on originalism as a method, a judicial philosophy. I think they're just trying to anticipate as well, or make a case to the public that it is the opposite party, the Democrats, who want to pack the courts by adding additional judges if the Democrats prevail in the next election and take control of the White House and the Senate. So both sides, it seems to me, are laying out their method in the next couple of days, their plan of attack, their plan of defense. And that, Judy, is something we always see in these Supreme Court confirmation hearings.
No question, Marcia Coyle, and we appreciate the Skype connection, and we appreciate the patience with that. We know that all of our guests, all of our analysts today and reporters are joining us remotely. Let me turn to you, Victoria Nurse, because the number of the Democrats have taken it as an assumption that what Judge Barrett would do if she's seated on the court is vote to overturn, undo the Affordable Care Act. What is it in her record, in her writing, in her opinions that has led them to this conclusion?
Well, she's written about the Affordable Care Act cases. And she's disputed the Chief Justice's interpretation of the law. So as one of the senators indicated, there has been a bit of an audition here. She is known for her theoretical writings about originalism. I think the real devil in the details is something called textualism, which we'll talk about. Right. But it's pretty much on the record. And she's also said, I am a Scalia justice. Now, I personally find that a little disturbing because I think justices should be independent. But nevertheless, we will get on with this and talk about her writings and see where she is on it.
And Victoria Nurse, it's not only that, it's her approach to the law that Democrats are coming after. I don't know how many of them have actually used the word originalism. It seems to me they've stuck to the Affordable Care Act. We've heard a couple of mentions of women's reproductive rights, but they are steering away from either, at least so far, dwelling on her faith. She's a devout Christian, a Catholic, or frankly, dwelling on her position on abortion, on reproductive rights.
Right, and I think that signals the shift that Justice Scalia really made on the court. He made statutes much more important and interpreting statutes. What's the difference between a statute and the Constitution? Well, the court has typically been viewed as having much more leeway to strike something down if it was clearly unconstitutional. But it has never been the rule until Justice Scalia, in my view, that they could rewrite statutes. Now, she's going to say, I don't rewrite statutes. That's not what I do. But look at what they've done. Look at the 3 challenges to the healthcare law. This is why the senators are so insistent on this. 2 of them had nothing to do with the Constitution. They had to do with how Congress wrote the law. And under her theory, she would have gone with Justice Scalia to say what was essentially a typo in the law would have meant that Congress had to repass it. No, that case would never have gotten to the court when I went to law school. He changed the court that way. And so what we are seeing is a true shift, in my view. It's not about the Constitution anymore. It's about any statute that Congress passes.
Sai Krishna Prakash, University of Virginia, and as we mentioned, you were a clerk for Justice Clarence Thomas. What are you hearing in the Republican arguments or in defense of Judge Barrett and in the Democratic charges against her that you think are or are not borne out by her writings and by her rulings? Sai Krishna Prakash, I'm not hearing you. Let's see, are we able to hear you now?
Sorry, Judy. I guess I was muted there.
You were muted. If you could just start at the top again. Thank you.
I'm happy to. Judy, I think the Democratic senators are focused on the ACA, as others have mentioned, and I think that's because that's a politically helpful issue to them during this campaign season. And I think they're suggesting that President Trump has got some sort of ace in the hole, and it's Judge Barrett, and that Judge Barrett will strike down the entire ACA. I don't think that will happen. I don't think that when Congress repealed the individual mandate, they implicitly wanted to have the entire act struck down, but that's the argument that the government is making and that several Republican attorneys general are making. So it's a good issue for the Democrats, and they're playing up to it. As you noted yourself, the Republicans are focused on what was said, I think, during the last confirmation hearing for Judge Barrett, a focus on her religious background and how that might weigh on her judicial decision making. But I don't think the Democrats are going to play that card again, in part because they felt that it backfired on them last time.
What about, Sai Krishna Prakash, what about her position on reproductive rights? What do we know from her record? It's not clear how much Democrats are going to bring this up. They've mentioned it in passing this morning, but what do we know from her record about her position on Roe and whether Roe should be overturned?
I think she's been she's identified publicly as pro-life. She's joined committees and organizations while a Notre Dame professor. But I don't know if we know what that means for the decision itself. The demise of Roe has been predicted many times, and it is yet to be fully overturned. Casey largely affirmed parts of it. So I think that will be an area for questioning for the Democratic senators. But as past nominees have done, I don't expect her to answer questions about how she decides particular cases. So it's all guesswork at this stage, Judy.
Marcia Coyle, I want to come back to you on something else that's come up, and that is several of the senators brought up the fact that if Judge Barrett is seated on the Supreme Court, she could be in a position to rule if the presidential election is disputed for or against, in favor of or not, President Trump. And we heard Senator Richard Blumenthal there toward the end a few minutes ago just say, I urge you not to take a position if you're on the court. What's the precedent there? Have there been justices who've been called on or in a position to weigh in after they've been selected? We know in 2000 with the Bush v. Gore decision, it certainly came up, but that was well after they'd been seated on the court. In this case, it would be just a matter of days.
That's right, Judy. I cannot think of a similar timing situation. I certainly remember that Justice Ginsburg, during the president's first campaign in 2016, did make some comments that were publicized in which she was critical of the candidate Donald Trump. And there were calls at the time that if he became president and he had cases that came before her, she should recuse herself because she was showing bias. As you remember, Judy, she did apologize for those comments. And when later cases, after he became president, much later cases came, and probably last term would have been the most direct case involving the president, the subpoenas for his financial information. There was no question about her recusing at all from those cases, and she did not recuse. Recusal is a very tricky thing at the Supreme Court. It's not like our federal appellate courts where you have many more judges sitting, and if one judge has to recuse, another judge can fill in. When there's recusal on the Supreme Court, you lose that person. So I think the situation that Judge Barrett would face if she becomes a justice and there is an election controversy immediately afterwards would be rather unique. And I suspect that in the next 2 days, there will be senators on the Democratic side who are going to press her for some kind of commitment about recusal. She has a general comment about recusal. She does recuse in cases in which her family may be involved. Her husband is a law partner at a law firm. If the firm or her husband is involved in any cases, but nothing of this kind, nothing so specific as an election-related controversy. So that is something I think, again, that the senators on the Democratic side will press her about. And that is something that if it comes to that, she has to make her own decision about recusal. The Chief Justice has said in the past that each justice makes that decision for him or herself when faced with a potential conflict.
Victoria Nurse, what do we know about anything she said in the past and in terms of precedent about what she might do if called on, if the court is called on to weigh in a disputed presidential election this year?
Well, I would hope that the court and the Chief Justice would understand that it is to the American people to decide who's the president of the United States. They should never have decided Bush versus Gore. It has put the chief and the entire court into a situation where most Americans now believe that they are politicized in some way. So I would hope that they would rule that it was, quote unquote, a political question, which means that they're not supposed to decide. There are no rules of recusal. There are guidelines. The rules don't apply to the Supreme Court. There's nothing that would, I tried to explain this to a reporter the other day, they couldn't quite understand. There's nothing that would actually require her to recuse. So I'll be interested to see what she has to say about that.
I was just going to turn to Sai Krishna Prakash at the University of Virginia. What do you see in her either statements or what she's written that give you any clue about what she might do under those circumstances?
Well, first, Judy, I hope there is no court case after this election. I hope the outcome is clear. But if it goes to court and ends up in the Supreme Court, I think she has a general methodology of originalism and textualism. And I think those are neutral methodologies that don't necessarily lead to outcomes that may favor or disfavor the president. Originalist judges have voted for this president. Originalist judges have voted against this president. So I don't expect that that methodology will lead to a conclusion that Trump will necessarily like. And I'll endorse what Professor Nurse said. I don't think that she'll be recusing herself. It's a little odd that Democratic senators who aren't going to vote for her anyway want her to recuse.
And I'm asking all this, of course, because President Trump himself said several weeks ago, around the time that he nominated her, he drew a connection between wanting to fill that seat and what he suggested might be the court having to decide on whether he's reelected or not. I think our Lisa Desjardins is in a place where she's not yet in a place where she can talk to us. Let me come to you, John Yang, who's been following this hearing. John, you've been watching these senators and anticipating the arguments they might make. How do you think how do you think this lays out what we're going to see over the next 2 days?
Well, I think that what Marcia and the others have said, the Democrats have made a calculation that they're going to go after and underscore the possible effects and outcomes of a Justice Barrett, perhaps a vote on the ACA when it comes before the court a week after Election Day. And the one reason why I think that has become such a focus of both Republicans and Democrats is because the attack on the law in this particular case is a textual one. It has to do with or it can be seen as having to do with a single word in the bill, shall. What does that mean? And I think that gives opponents of the ACA some hope that she would vote to strike it down. We don't know that. Her writings have been about previous cases which rested on different things. And I think that also you're hearing the preemptive strike by the Republicans on her religion that goes back to her confirmation hearing for the circuit court, for the appeals court, when Dianne Feinstein, the ranking Democrat, said that the dogma was strong within her, that I think a lot of Democrats now see as perhaps an unfortunate wording or if not a full mistake, and that allows the Republicans to try to paint the Democrats as being anti-religious, as anti-Catholic, anti-faith. But I also think that we're not going to hear, we will hear later on a brief opening statement from Judge Barrett herself. She's not going to give us much much indication on positions on law that she has not already written on as a judge. It will go back to, I think we heard Senator Grassley quote Justice Ginsburg in her confirmation hearing saying no forecasts, no hints, because it would be disrespectful to the judicial process.
And I want to come back, John, and maybe I will throw this quickly to Marcia, a question about what remind us exactly, Marcia, what it was that Judge Barrett has written about Chief Justice Roberts and his ruling on the Affordable Care Act, interpreting it as a part of the requirement that there be a fine, if you will, that it be connected or be interpreted as a tax. Why that matters, why Democrats are seizing on her comments on that.
Well, as you recall, in fact, because many of us recall, the Chief Justice was the critical vote in upholding the obligation to purchase health insurance under the Affordable Care Act, because he said it was constitutional because there was a tax penalty, and he viewed it as constitutional under the Constitution's under Congress's power to tax and spend. Now, in 2017, Congress eliminated the penalty, and so without the penalty, the Republican-led charge against the act in the new term here is that it is no longer constitutional because the basis for upholding it is gone. Judge Barrett wrote in a law review article that in 2012, when Chief Justice Roberts upheld it as a tax, a constitutional tax, that he pushed the he pushed the Affordable Care Act beyond, and these are her words, I believe, its plausible meaning. And that is what has concerned the Democrats, that she did look at the text and the Constitution in 2012 and appears she would have come to a different result in that case. And so their concern is that she would once again see in what was done textually by the Congress on the eliminating the tax penalty, that it will again be unconstitutional. I have to tell you, Judy, that there is serious bipartisan agreement that the arguments against the Affordable Care Act in the Supreme Court now are almost frivolous. They don't have much grounding in law. And the real issue may be if the court does find that the mandate is no longer constitutional because of what Congress did, the court will face a second question, and that is whether they can, and whether the justices, under a doctrine known as severability, can cut out the unconstitutional provision and still maintain the rest of the Affordable Care Act. So there are really two issues that may face Judge Barrett if she becomes the justice, and the rest of the court when it comes to the Affordable Care Act. But yes, you're absolutely right. It's what she wrote in that, I think it was a 2013 law review article, that has given Democrats a lot of concern about what she will do with the Affordable Care Act.
And I'm asking because, Marcia Coyle, because it has come up in the comments of one Democrat. I would say almost every Democrat has raised the Affordable Care Act in his or her, excuse me, in his or her comments. Our Lisa, excuse me, our Lisa Desjardins is now at a place where she can talk to us outside the courtroom. So Lisa, unusual scene with not only the senators distanced, but the audience distanced, very few reporters allowed in the room. Give us a sense of what it felt like in the room with the justice, her family behind her, and the whole picture.
I want you to imagine a large gymnasium, which is probably what this looks like on television. But in that room, you get a sense of the vastness of the building and the chamber that you're in. And I've been in that room many times for hearings where we were packed, more than 150 reporters at some times. Today, there were 12 reporters here, 7 still photographers. Each senator could have only 1 staffer with them. Many of them opted to have no staffers. In general, Judy, it was good to see that nearly everyone remained masked as they've been requested to do. The exception to that was the chairman of the committee himself, Lindsey Graham, who rarely wore a mask. He did put one on one time. That was when Senator Mike Lee came to speak with him. And of course, as our viewers know, Senator Lee tested positive for the coronavirus 10 days ago. He said he's been cleared by the office of the physician here at the Capitol to attend this hearing. He says he is not at all someone who can contribute or pass around the virus. He's not contagious. But, you know, he spoke without a mask in that hearing. His neighbor next to him, Senator John Cornyn, did not wear a mask when Senator Lee was speaking without one. So you really see these politics of masking happening at this moment. One other note, Mark Meadows, the president's chief of staff, is here along with White House counsel Pat Cipollone. Mark Meadows came to speak with the press just a few minutes ago, came up to the microphones. Here at the Capitol, the press corps unanimously has decided we are asking lawmakers to remain masked when they speak with us. Mark Meadows was asked to keep his mask on. He said he didn't feel that was appropriate. He thought he was far enough away. The press corps said, no, we insist that you wear your mask. And he instead decided to move on, and he said he would not speak to reporters if he had to wear a mask. So this is the atmosphere we're in right now. It's unusual. All that aside, Judy, I'll say, with the exception of the coronavirus crisis hanging over us, which is very significant, and you feel it in the room, this was actually a less tense room than I recall from the early Kavanaugh hearings. It was more serious. I think that Democrats, as your panel may have been suggesting, are resigned to where the votes are on this. And that led to a more substantive, less combative discussion than I've seen. There are protesters here. The only ones I've seen are in favor of Amy Coney Barrett, actually joyous supporters in favor of her, largely women's pink signs in favor of Amy Coney Barrett, outside chanting for her. I have yet to see opposing protesters, though Capitol Police tell me they are prepared and they do expect some.
And Lisa, there was a report earlier about arrests outside the building or outside the hearing room. Do we know anything about that?
I'm afraid I don't. That shows you what kind of tunnel vision I
No.
have in the room.
No, we know your movements are very restricted, but at least I do want to come back to something, and that is Amy Coney Barrett herself was wearing a mask, as was every member of her family. At the White House announcement event, over 2 weeks ago, she nor her family members were wearing a mask, nor was the president. And of course, that's now been identified, including by Dr. Tony Fauci, as a super spreader event. It's interesting that she is wearing a mask at this indoor event, and it will be interesting to see if that continues throughout the hearing.
That's right. She and every member, not only of her family, but of her team, the 6 White House staffers, including the chief of staff, Mark Meadows, who were with her, were all wearing masks. And, you know, it could be argued that she was maybe the most isolated of anyone in the room. She was the most distant from anyone else. And yet clearly she knew she would be on camera for this, and she decided to wear a mask throughout.
I want to come back to you, Lisa, in a moment, but I'd like to turn now to Yamiche Alcindor, our White House correspondent. Yamiche, so much is riding on this for the president, for the White House. As Lisa just mentioned, Chief of Staff Meadows is there at the hearing. How is the White House watching these hearings? How much do they see it connected to the president's reelection prospect?
Well, the White House and President Trump are watching these hearings very, very closely. As Lisa said, you have the White House Chief of Staff going there in person to make sure that he is that the public understands that this is the White House pushing for this nomination to go through. The president feels as though Judge Barrett is really an embodiment of conservative goals that they've been trying for decades to get realized. The president has said over and over again that he sees Judge Barrett as connected to his legacy. He sees this as a way for him to, in some ways, reach out to Republicans, especially evangelical white Republicans, to say, I am still the president that will get you the things that you want as a conservative and as an evangelical voter. The president has, of course, had so many different struggles in 2020. His response to the coronavirus has been a real issue for him. He's downplayed the virus a number of times, admitted to that. But when you talk to voters who don't like the president's style, don't like the brashness, don't like the scandals, don't like all sorts of other things that the president does, doesn't like the tweets, They go back to the Supreme Court and the promise that the president made to voters, which was that I will pack the court with Supreme Court nominees that are made in conservative values and have conservative values. And that's what the president has done. His third nomination we see here. We also think that there was something really interesting going on in the hearings. And that is that, of course, as you mentioned, Democrats were talking a lot about healthcare, a lot about specific policies, abortion, a lot about all sorts of other things that could happen if they see Judge Barrett having going on the court and not having the same ideals as them. And you saw Republicans really want to talk about constitutionality, saying that they're obligated to have this strategy, that they're obligated to confirm this nominee. And they didn't really talk that much about policies, but President Trump has made it clear over and over again that he wanted a justice on the Supreme Court that would overturn Roe v. Wade. He said it in 2016. He said, if I get elected, I will automatically move forward with trying to make sure that Roe v. Wade is overturned. He also said that every single justice that he put on the court, that they would be in favor of overturning Roe v. Wade. He also talked about the Affordable Care Act and saying that he wants that overturned. He wants it repealed. The Trump administration has not come up with their own health care plan, but they've made it very clear that they want to do away with President Obama's health care plan. And lastly, as you noted, there's an election coming up, and the president has been crystal clear just last month saying, I want someone who is on the Supreme Court who will see me as the rightful person to move forward, because the president has said without evidence the Democrats are rigging the 2020 election. So we can also see the president making clear that he believes not only is his reelection hinged on this idea that he can point to Judge Barrett and say, this is a goal that I got. He also thinks that if there is some sort of contested election, that Judge Barrett could be the vote that would allow him to serve another 4 years.
Exactly. This nomination, more than any other, because of the proximity to the election, brings us back time and again to what it could mean for this president, what it could mean for the policies that he espouses. I do want to just quickly go back to our two analyst guests, Victoria Nurse and Sai Krishna Prakash, on what's at stake here. And just quickly to you, Victoria Nurse, what is at stake here in terms of the court moving from 5-4 conservative majority to potentially what looks like will be a 6-3 conservative majority for a long time to come?
Well, it's decades. My children and my grandchildren. So that's why the senators are talking so much about so-called policy on the Democratic side, because the court has taken a position where it not only can overturn statutes because they're unconstitutional, but they can reread them in a way that they don't work. So they've taken on a lot more power, and this will solidify that power. And that power, in difficult cases, often comes down on the side of where your political party is. It's not because the justices try to do that. It's just that there are two different answers. Originalism isn't neutral. I think most people don't think we should go back to 1787 for dentistry, so I wouldn't go back there for the Constitution either. And textualism isn't either, because you can pick one word, as Marcia said, and suddenly the law that's 900 pages is gone. So what's really at stake is a long, long tradition. Justice Scalia created something entirely new. It is not traditional. And this new tradition, this invented tradition, is going to determine where my daughter and granddaughter and grandson, how they will live. And these are by unelected persons. That's why the Judiciary Committee is focusing so much on policy, because the court does determine that.
And Professor Sai Krishna Prakash, what about from a conservative perspective? What difference could it make for this court to go from 5-4 to 6-3 with a conservative majority?
Judy, I kind of disagree with Professor Nurse. I think the way to think about this is it's a marginal change that can be undone by future presidents who will be appointing their own justices. If Senator Biden, maybe President Biden wins, he'll be appointing justices, I think, that adopt his sort of judicial philosophy. So I don't think this is going to be a generational change, because as we know, there are many other old justices on the Supreme Court. And unfortunately, everyone's time comes sooner or later. So I don't view this as generational, but of course, every Supreme Court fight in the last several decades has been a knockdown, drag-out fight, because people always perceive it to be the last domino to fall.
And you mentioned if Joe Biden is elected, but of course, if President Trump is reelected, there would be a Republican in the White House for another 4 years.
Of course, no, I can't. I'm not predicting who's going to win.
And Victoria Norris, what about that? I mean, why couldn't it be seen as just, this is another appointment and in a couple of years or less, there could be another change?
Because Justice Scalia was not exactly a shrinking flower. We know what he has already ruled on, and it would change lots of things in Americans' lives. One measure of this is my colleague over at the main campus on Georgetown has come up with his ideological scores, which are in the hard cases. In the easy cases, she'll rule with the other justices, I'm sure. But in the hard cases, the contested ones, he's found that a 6-3 shift would in fact turn the court ideologically back to approximately the 1950s. And so I do think this is quite significant. I think that on a variety of issues, this is why she's presented in a particular way where everyone's talking about the gender issue. I don't think they spent as much time on male nominees and their families. And she's viewed as an icon for having this amazing career and amazing family. But that's what is the image is reflecting a deeper reality if Michael Bailey, my colleague, is correct about ideology. And he doesn't believe the court is always ideological. He thinks it's not ideological for most of the cases. I think that's what we all agree. We lawyers, we revere the court. The problem is that the court will get into trouble if it's confused about its mission. And its mission is to support the rest of the government, not to make radical changes in government policy. Unfortunately, I don't think that that's what this philosophy does. I think this philosophy is, it's something of a smokescreen, as one of the senators said. It sounds really anodyne and very bland, but in fact, it's already been shown in the Healthcare Acts in both of these statutory cases. They're not constitutional cases, based on very thin reads. And so part of the problem is that you can use this philosophy to make hash of almost any statute if you want. And I know that Judge Barrett knows that because I've debated her about this. She believes it, but I think the evidence shows that it doesn't quite work out that way.
And Sai Krishna Prakash, why is that wrong? Why is that analysis that it could take us back to a court from the 1950s not correct?
Because I think, Judy, I think the court already has a conservative majority, but what we've seen is that the conservative majority wedded to a methodology comes to conclusions that aren't predictably conservative, right? Think of the Bostock case. That was a textualist opinion signed onto by liberal justices as well. That was not, did not lead to the conservative outcome, or at least a conservative outcome of a certain sort. And then I think more generally, there are going to be other nominations. There is no end to history, and there is no end to these nomination fights. And so I don't think that this presages a 1 or 2 generational change in the Supreme Court. As Barack Obama said, elections have consequences. President Trump won, so he's nominating people that he thinks would be best suited for the court. And if Senator Biden wins, he will do the exact same thing. And I can guarantee you they won't be like Judge Barrett.
Marcia Coyle, I want you to weigh in on this as you watch the court so closely.
Okay. I think when I think of the 6-3 conservative majority, I also think about Chief Justice Roberts. Right now, well, in a 5-4 majority, Roberts was median justice, not the swing justice, but a justice who was able to control, or had the ability to control, how far and how quickly the court could move the law to the right for the most part. And I think with a 6-3 majority, his ability is diluted. If he is in the majority, he still retains the power to assign opinions. So there's a certain amount of control there. But I think overall, what we saw last term, when he was able to form majorities with the left in order to reach opinions in some very hot issues involving not only President Trump, but also involving Dreamers the LGBTQ employment discrimination case, that he was very essential to that. I think with a 6-3 conservative majority, even though for the most part he will be with the other conservatives, he will not be able to have as much ability to control, as I said, how far and how quickly the court moves, as well as what he is known for, which is to have a very close eye on the institution's reputation and integrity with the American people. It doesn't mean he decides cases because he's always worried about what the American people might think. It's just that he takes a step back, and while weighing everything, he also has to weigh the continuing credibility of the Supreme Court with the American people, because that is essential to the American people's belief in the rule of law. And I think a 6-3 majority really does have an impact on him. And then that raises the question of, well, is there going to be another median justice? Who would that be? And I guess if you look at how the votes have gone in the last 2 terms or so, that the median justice might be Brett Kavanaugh. And I don't think that he would be the same kind of median justice as Roberts from what I've seen thus far. But it's still very early in Kavanaugh's career on the Supreme Court to make any judgments about him in that kind of a role. So I think the 6-3 conservative majority does have a real impact. And there's less of a need to try to bring on board in key cases the 3 justices on the left. And that would be unfortunate.
All right, let's go back to the United States Capitol, to our Lisa Desjardins, who's been in the hearing room and is watching all of this. Lisa, give us a sense of what to expect. I mean, is there an expectation that any of these senators is going to change? There's no question all the Republicans are going to vote in favor of Judge Barrett. We assume all the Democrats are going to be opposed. Do you see any sense of minds changing as a result of these hearings over 4 days?
I do not. And you heard Senator Klobuchar say as much in the hearing. Also interesting, one of the 2 Democrats who has spoken with Amy Coney Barrett, Senator Chris Coons of Delaware, had a phone call with her last week. He spoke with me and other reporters after that phone call. And we asked, do you think there are, and he's known as being bipartisan, talking to Republicans, are there any Republicans who may be on the fence here? He said there are Republicans he's speaking with who have questions about Judge Barrett, maybe some sort of doubts, but he said he doesn't think that they are large enough doubts to change them from voting to voting against her. I do think this next part of the hearing, although it will be the shorter part, we have maybe an hour and a half left today, it looks like, will be interesting because there are a lot of political stakes involved. We have 7 senators remaining to speak. In that group are 2 vulnerable Republican senators, or I'm sorry, 1 vulnerable Republican senator, Senator Joni Ernst. You heard from Senator Tom Tillis in the first half, and also the vice presidential nominee for the Democratic Party, Senator Kamala Harris. So it is going to be very important to them to see how Harris, how widely does she speak? How much does she speak to the Democratic base? And the same thing for Senator Ernst. She has been someone who she needs Trump voters in her state to show up for her, but she also has to have some kind of wide appeal. How does she handle this nomination? I'm going to be very interested to see. And of course, we'll hear from Judge Barrett herself as well. There will be 3 people introducing her, 2 senators, and one of the former deans of the Notre Dame Law School as well.
Will be so interesting to. It's so interesting and important to keep in mind what the political pressures and otherwise are on these senators as they consider the nomination, as they think about what they're going to say. Lisa, refresh our memory on this. How many of the Democratic senators, either on the committee or overall, have agreed to meet with Judge Barrett?
Well, it depends on how you phrase that question. So far, 2 of them have spoken with her. Joe Manchin of West Virginia has met with her in person. And as I said, Senator Coons spoke with her on the phone. Right. I know that Senator Booker has said if she wanted to meet, that he wants to talk to her. I don't know if that's an official meeting or quite what that means, but those are the only ones that I know have been very open about saying they would like to speak with her. I don't know if there's hard no's from the rest.
And as we watch Judge Barrett come back into the hearing room, followed by members of her family, we're waiting for the chair of the committee. And I can't see if Lindsey Graham is in his seat just yet. Let me turn quickly back to John Yang. John, as you watch the senators weigh what they're going to do about this nomination, does it strike you how many of them pre-announced what their vote was going to be?
Well, I think you heard Chairman Graham say it right in his opening statement. This is not an exercise in trying to persuade one another. He said he fully expects all the Democrats to vote against, all the Republicans vote in favor. And I see Senator Hirono is now beginning her questioning.
Let's go directly to the hearing room. This is Senator Mazie Hirono of Hawaii.
The White House has become a COVID-19 hotspot, driven by the president's ongoing denial of how serious this pandemic is. Not even contracting the virus and being hospitalized seems to have shaken him back to reality. In normal times, the Senate would be focusing our attention on passing legislation to help the millions of Americans suffering during this pandemic. But these are not normal times. Instead, Senate Republicans are rushing to put a nominee onto the Supreme Court to be the deciding vote to take health care away from millions of people. President Trump has been very clear about what he's doing. He's repeatedly promised to appoint Supreme Court justices who will strike down the ACA. And by nominating Judge Barrett, the president is keeping his promise. In her speech at the White House COVID super spreader event 2 weeks ago, Judge Barrett aligned herself with her mentor, the late Justice Antonin Scalia, who twice voted to strike down the ACA. To help the president keep his promise, our Republican colleagues are rushing to confirm Judge Barrett in a hypocritical, illegitimate process mere weeks before the election. They want Judge Barrett seated just in time to hear the Republican lawsuit challenging the ACA a week after the election. For Americans dealing with this pandemic, it must seem outrageous that Donald Trump and Senate Republicans are determined to take away their health care and are just as determined to do nothing to help Americans with a new COVID relief bill. And they're right, it is outrageous, but it's not surprising. Republicans have made it clear for the past decade that repealing the Affordable Care Act is at the top of their hit list. We know this because a mere 2 weeks after assuming control of the House in 2011, Republicans voted to repeal the ACA for the first time. And over the next 6 years, Republicans took at least 70 votes in Congress to eliminate provisions of the ACA or to repeal it altogether. These repeal efforts culminated in the early morning hours of July 28, 2017, when our late colleague, Senator John McCain, gave his dramatic thumbs down and saved health care for millions by one vote, his vote. Faced with their 70 failures to get rid of the ACA in Congress, Republicans have taken to the courts. Right now, the Trump administration and 18 Republican state attorneys general, including those from Texas, South Carolina, and Missouri, are at the Supreme Court right now trying to strike down the ACA. All arguments in the case are scheduled for November 10th, a mere week after Election Day. This latest legal effort has been turbocharged because of the death of our champion, Justice Ruth Bader Ginsburg, only 3 weeks ago. Her death has changed everything for Donald Trump and Senate Republicans. They are confident that victory at the Supreme Court is now within their grasp if the Senate confirms Judge Barrett through this hypocritical, illegitimate process. The consequences of Judge Barrett's confirmation would be devastating for millions of Americans who would lose their health care during this pandemic. Even in normal times, without the threat of a pandemic, no one in our country should have to confront a major illness worried that it might bankrupt their families. But we all know these are not normal times. Healthcare is the #1 concern for so
Quickly interrupting Senator Hirono, as the committee is now back from its lunch break and opening statements have resumed, we are going to start preparing for our own NewsHour program, but stay right where you are. Our uninterrupted coverage will continue on PBS stations and online on our website, on YouTube, and on other social media channels throughout the conclusion of today's hearing. I'm Judy Woodruff. Thank you for joining us. Please stay with us.
Thankfully, the ACA enabled her to get health care. She used that coverage to get a checkup and a mammogram, which found her breast cancer. With her health insurance, she was able to get a mastectomy and has been cancer-free since. Kimberly credits the ACA for saving her life. She said, quote, "If it wasn't for the Affordable Care Act, I probably wouldn't have had that mammogram. I was diagnosed early. It scares me to think, if I didn't have insurance, how far advanced would the cancer have grown?" Kimberly's story is not unique. In the years of all the battles of eliminating the ACA, we've heard from hundreds and thousands of constituents across the country sharing their healthcare stories. Dean Oda and his daughter Jordan are from my home state of Hawaii. Jordan, who is an elementary school teacher at Eva Beach Elementary School, has PNH, a very rare blood condition. To treat this condition, she gets infusions of a special medicine that costs around $500,000 per year without insurance. Dean told me that, quote, "Without this medicine, she will die." Dean and Jordan live in fear that Republicans will strike down the ACA, which would allow her insurance company to put lifetime caps on her benefits, and she would be left without coverage for her life-saving medication. Dean wrote to me to share how, quote, "extremely terrified he is about his daughter losing access to adequate health care under the ACA. He's asked me to fight for her, and that's what I'm doing today. Healthcare is personal to Kimberly, Dean, Jordan, and it's personal to me too, because I know that having health insurance and access to healthcare saved my life. On the day when the Senate confirmed Neil Gorsuch to the Supreme Court, I got a routine chest x-ray before a scheduled eye surgery. A shadow on that x-ray and a later scan led to my diagnosis of stage 4 kidney cancer and gave me time to receive treatment. My diagnosis came as a total shock, and I'm grateful it came when there was still time. I still have cancer, but I don't need any treatment right now. I receive regular scans so that I will know in time if treatment becomes necessary again. I'm grateful for the care I've received and continue to receive from my doctors. The cost of my treatment, which included surgery to remove a kidney, a second surgery to remove part of a rib replaced with a 7-inch titanium plate, almost 2 years of cutting-edge immunotherapy and regular scans, has been enormous. It would bankrupt almost every family in this country if they didn't have health insurance. I'm not special or unique. Serious illness can hit anyone unexpectedly. It did for me. And when it does, no one should have to worry about whether they can afford care that might save their life. The Affordable Care Act provided this peace of mind for so many people over the years who found themselves in positions similar to mine. Their lives and their health are what's at stake. Their lives are what's at stake with this nomination. And at moments like this, where the healthcare of millions is on the line, I think back to the care and concern so many of you showed me when I was diagnosed with cancer 3.5 years ago. So many of you, including many of my Republican colleagues on this committee, wrote heartfelt notes wishing me well and letting me know you were thinking of me. And to this day, when the chairman of this committee and I find ourselves away from the cameras or sharing an elevator, he never hesitates to ask me about my health. He says, "How are you doing?" Mr. Chairman, you and I have had our pointed disagreements over the years, particularly during our time together on this committee. But your concern means a lot to me. Moments when we recognize our shared humanity are rare in Congress these days. But this can, it should be one of those moments. This can be a moment, Mr. Chairman, for you and your Republican colleagues to show the American people terrified about losing their health care the same care and compassion you showed me and continue to show me when I was diagnosed with cancer. Instead of rushing to jam another ideologically driven nominee onto the Supreme Court in the middle of an election when over 9 million Americans have already voted, Mr. Chairman, let's end this hypocritical, illegitimate hearing, return to the urgent work we have before us to help those suffering during this pandemic. Thank you, Mr. Chairman.
Thank you, Senator Rono. I think it's not just me. I think everybody on this committee and everybody that knows you're passionate about your causes. We have a lot of political differences, but all of us are very encouraged to hear that you're doing well, and we'll keep praying for you. You're an asset to the Senate.
I appreciate that. Thank you. Do the right thing.
Okay. Senator Ernst.
Aloha.
Aloha. Senator Ernst.
Thank you, Mr. Chair. And Judge Barrett, thank you so much for being in front of us today. Welcome to you. And of course, I am so glad that you have had your family join you today as well. Only 100 years ago, women in this country were given the right to vote. And today we consider adding another woman to the highest court in the land. And I can't help but be so proud of all of every one of our women have accomplished in this incredible nation. This is the first time that I've been a member of the Judiciary Committee during a Supreme Court nomination process. And as you probably know, like most Americans, I'm not a lawyer. I bring a slightly different perspective onto this committee. But one thing is very important to me, and it's something that matters to Iowans, whether they are lawyers or not. I firmly believe in the role of our Supreme Court. It is the defender of our Constitution. At the end of the day, that's my test for a Supreme Court justice. Will you defend the Constitution? It frustrates me and it frustrates my fellow Iowans that the Supreme Court has become a super legislature for a Congress that frankly won't come together, discuss these tough issues, and do its job. What I hear from colleagues on the left is about judicial activism and what they want to see in their nominees, which is that super legislature. They are projecting that upon you, Judge Barrett. That's what they are projecting as they talk about what cases may or may not come in front of the Supreme Court. Matter of fact, I think it was just the other day that Vice President Joe Biden told the American people they don't deserve to know whether he is going to pack the court. They don't deserve to know who his judicial nominees would be. I think we do need to know, again, because what the left is projecting on you today is what they want to see in their nominees. But that's not what our founders intended the court to be. I hope that this hearing will be an open, fair conversation about how Judge Barrett would be as Justice Barrett. I am concerned, however, that not everyone involved in this hearing shares that goal. We've already seen hints in that over the past few weeks, immediately attacking your faith and your precious family. Instead of entering into this nomination process with an open mind and a desire to understand this woman who has been nominated for the highest court in the land, The focus is on a plan or a strategy, a series of tactics to undermine, coerce, and confuse the American people. A plan, Judge Barrett, to undermine you as a person, undermine your family, and undermine what you hold dear. Women all over the world are painfully familiar with this strategy. We are all too often perceived and judged based on who someone else needs or wants us to be, not on who we actually are. I cannot speak for those that would attempt to undermine your nomination, but as a fellow woman, a fellow mom, a fellow Midwesterner, I see you for who you are. And I'm glad the American people have the opportunity to get to know Amy Coney Barrett. This week will be an opportunity to dig into your background further and understand more about your judicial philosophy. But what your political opponents want to paint you as is a TV or cartoon version of a religious radical, a so-called handmaid that feeds into all of the ridiculous stereotypes they have set out to lambast people of faith in America. And that's wrong. It might be less comical if this was the first time the left has trotted out this partisan playbook. Your political opponents have made these types of religious attacks on nearly every Supreme Court candidate nominated by a Republican president in the modern era. And every time, like clockwork, they say they really mean it this time. This nominee, this woman in front of us, she is the absolute worst. I'm struck by the irony of how demeaning to women their accusations really are. That you, a working mother of 7, with a strong record of professional and academic accomplishment, couldn't possibly respect the goals and desires of today's women. That you, as a practicing Catholic, with a detailed record of service, lack compassion. I know you to be compassionate. Your record on the 7th Circuit says that you are. And more importantly, it shows that your demonstrated commitment is to defending the Constitution. The great freedom of being an American woman is that we can decide how to build our lives, whom to marry, what kind of person we are, and where we want to go. I served in the Army, something not exactly popular at various points in America's history. We don't have to fit the narrow definition of womanhood. We create our own path. Justice Ginsburg was one such woman, and I would like to pay tribute to her for what she did to pave the way for women of today. It's really quite simple what your opponents are doing. They are attacking you as a mom and a woman of faith because they cannot attack your qualifications. Every year, I travel to every single one of Iowa's 99 counties and talk to men and women from all walks of life. Whether they are farmers or nurses or small business owners, they want a government that is accountable to them. When Congress makes a law that oversteps the Constitution, the ripples can be felt, whether it's on farms in Montgomery County, where I'm from, and the manufacturing facilities of Dubuque. It can be felt in the church services of Sioux City and the community meetings in Waterloo. The Supreme Court's only job is to rule on the cases before it and defend the Constitution. To do that well, a justice needs to be thoughtful, restrained, and wise. Judge Barrett, so far I have seen all of those things in you. I am so glad that we have you in front of us. I look forward to learning more about you. I want to thank you and your family for being in this nomination today. And certainly this, folks, is what a mom can do. Thank you, Judge Barrett, very much. Thank you, Mr. Chair.
Senator Booker.
Thank you, Mr. Chairman. Behind me, Merritt Bowman is a 49-year-old father of twin boys, which you could see, and a football coach and paraprofessional at Deptford High School in New Jersey. For years, Merritt put off going to the doctor because he was, like many Americans, afraid he could not afford it. But when the Affordable Care Act was passed, he finally got the coverage he could afford. 4 years ago, after not feeling well, Merritt made the doctor's appointment and was diagnosed with type 2 diabetes, a disease that affects over 10% of Americans and disproportionately impacts Black Americans like Merritt, who are 60% more likely to be diagnosed with diabetes and twice as likely to die from it. Today, Merritt takes insulin and other medications, and his condition has thankfully improved. Merritt said, and I quote, "Obamacare made it so I was not afraid of the costs of going to the doctor. If I didn't have insurance and didn't get diagnosed, who knows where I would be right now." But Merritt is worried about what will happen if the Affordable Care Act gets overturned. He said, and I quote, "Now I have a pre-existing condition. My insurance covers my medications, my equipment to monitor my diabetes. If that's taken away from me, what's going to happen? I can't afford those on my own." Michelle Luris from Palisades Park, New Jersey, lost her husband, John, last year when he passed away suddenly at the age of 58. Michelle relied on health insurance through John's job, but when he died, their insurance went away. She was given the option to continue his plan, but she couldn't afford the cost of $800 a month. So Michelle signed up for coverage on the insurance marketplace, where she qualified for a subsidy that made it more affordable. Today, she's insured and she can manage her diabetes, heart disease, and an autoimmune disease because of her coverage. Like Merritt, Michelle also relies on insulin and other prescription medications. If the ACA was overturned, Michelle said, quote, "I could lose my house if I didn't have affordable health care. I would have to sell my home. I like where I live. I don't want to lose my home." People like Merritt and Michelle are understandably scared right now. President Trump has told America he would end the ACA. He promised explicitly that he would only nominate judges that would do the right thing and eliminate the Affordable Care Act. People like Merritt and Michelle know what a future without the ACA looks like. It looks like 130 million Americans with pre-existing conditions, from cancer survivors to people with disabilities, being charged more or denied coverage completely. It looks like 20 million Americans losing their access to potentially life-saving care in the middle of a pandemic that's already killed over 214,000 Americans. In New Jersey, we've lost over 16,000 people to COVID-19. 595,000 people would lose their coverage without the ACA. For millions of Americans, a future without the ACA looks like being forced to sell your house if you can't afford your health care. It looks like not having access to a doctor when you're sick. It looks like having to choose between paying for groceries and paying for medicine. And people are scared right now for another reason, because they know what a future without the protections of Roe v. Wade looks like, because President Trump has explicitly stated that he would only put up Supreme Court nominees that would overturn Roe v. Wade. He said it clearly. We should believe him. And that, without Roe v. Wade, our country looks like people being denied the ability to make decisions about their own bodies, not just while they're pregnant, but being stripped of the right to plan for their futures. It looks like women of color, low-income women, and women living in rural areas who can't just pack up and leave if abortion is restricted or criminalized where they live. It looks like them being left with no options. It looks like state laws proliferating throughout our country that seek to control and criminalize women. It looks like the government interfering with women making the most personal medical decisions. It looks like a country in which states may write laws that could subject women who have miscarriages to investigations to ensure they didn't have abortions. In America today, people are scared. You've heard from my colleagues. We're getting calls to our office where people are afraid. More than 214,000 Americans have died, many of them isolated and alone, away from friends and families. Tens of millions of jobs have been lost. 1 in 3 American families with children aren't getting enough food to eat. More than 100,000 small businesses have closed permanently. Lines at food banks in the wealthiest nation on the planet have stretched for miles. We could be, as the Senate, we should be, as the Senate, working in a bipartisan way to try to get this virus under control, to get relief to people who are hurting, who are struggling, who are afraid, to help people who are unemployed, to let doctors and nurses and hospital staffs putting their lives on the line right now in state after state where COVID is rising, know that we have their backs in a pandemic. But instead of doing anything to help people who are struggling right now, we are here. We're here. I'm so glad. I'm really glad that my colleagues who contracted COVID-19 at the Rose Garden Super Spreader event for Judge Barrett had access to the care that you and your families needed. That is right. This is a blessing. The problem is the people who will come through here today to wipe down the desks and empty the garbage, that will vacuum the floor, like people all over our country who are working today in factories, teaching children in schools. They don't have direct line to the nation's top health experts. They can't show up to work sick, and they might not have space to distance themselves at home to protect their families. We literally stopped the Senate from functioning with the exception of this hearing. That's why we're here. We're not just 22 days from an election. We're in the middle of an ongoing election when millions of people have already started voting because Donald Trump and most of my Senate Republican colleagues know the truth. They won't be able to get away with this after the American people have spoken in this election. Donald Trump and my Senate Republican colleagues in this room today know that the American people don't want the ACA overturned. Donald Trump and my Senate Republican colleagues know that the majority of Americans actually don't want Roe v. Wade overturned, that the majority of Americans don't want to see abortion criminalized in our states. But that is exactly why we are here today, because Donald Trump and Senate Republicans know that the American people don't want this, so they have to act now. They don't trust the American people, which is so painful because that's what they said. They said we should trust the American people, and what the American people say under President Obama 269 days from an election. And then after that election, they tried time and time again to overturn the Affordable Care Act, but a handful of Republicans stopped them. You see, they tried in the Senate, they tried in the House, over 70 attempts to rip down the Affordable Care Act, but now Donald Trump has said he's going to do it through the courts by making the nomination we see here today. That's why we are here. The American people should know that that is what this is all about, rushing this nomination through to sit a Supreme Court justice in time to hear a case before the Supreme Court that will end the Affordable Care Act. We're here because in the middle of a deadly pandemic, in the middle of an ongoing election, Senate Republicans have found a nominee in Judge Barrett who they know will do what they couldn't do, subvert the will of the American people and overturn the ACA and overturn Roe v. Wade. That's what this is about. That's why we're here. It's very simple. Senate Republicans know the American people don't want this, but they don't care because they have only one small window of opportunity to work the system, betray what the American people want. And so they're desperately rushing to complete this process before America starts voting, but they don't have to do this. If one of my colleagues will stand up on this committee, we can hold this over until after an election. If two of my colleagues on the Senate floor agree with their other two colleagues, Republicans, we can stop this. Otherwise, this is a charade when they say this is a normal Judiciary Committee hearing for a Supreme Court nomination. There's nothing about this that's normal. It's not normal that Senate Republicans are rushing through a confirmation hearing, violating their own words, their own statements, betraying the trust of the American people and their colleagues, and failing to take in this hearing even the most basic safety protections to protect people around them, all to ensure that tens of millions of people will lose their health care. When we're one of the worst public health crises in the history of our country. It's not normal. This is not normal. That millions of Americans like Michelle and Merritt are just scared of a deadly virus. They're scared of their fellow Americans who are sitting in this room right now. They're scared that their government and their institutions will be manipulated by people who could not work through the democratic process to take away their health care and are trying an end run to achieve that. Nothing about this today is normal. This is not normal. What is going on in America today, in the midst of a deadly pandemic and an ongoing election, having a rushed Supreme Court nomination hearing is not normal, and we cannot normalize it. People are voting right now. The American people should decide. The American people should decide. The American people should decide. I will not be voting to confirm Judge Barrett's nomination.
Thank you. Senator Crapo.
I would like to submit a letter for the record, if I may. We should not be rushing, as I said, this process. My colleagues agree with me that we should be working to protect the health and safety of Americans across the country and taking the precautions, greater precautions in this workplace. I'd like to enter into the record a letter from Senators Leahy, Senator Harris, and myself that we sent to the chairman last week asking that these hearings not proceed without proper testing measures, without all of us being tested and a COVID safety protocol being put into place.
Thank you. Without objection. Senator Crapo.
Thank you, Mr. Chairman. Judge Barrett, welcome and congratulations on the high honor of your nomination. I have some prepared remarks here, which I will give. But having sat through the speeches that I've heard already and listened to the attacks that have been made, both on Republican members of the committee and on you, I think it's important to just set the record straight on a few items before I then talk about why we are here, and that is you and your qualifications to serve as a justice. So what were the attacks? I'd say the first one is that we're rushing too fast and that we are violating the rules and norms and precedents of the Senate and speeding into these proceedings. What are the facts? Well, I had my staff check while we were sitting here. This hearing is 16 days after Judge Barrett's announced nomination. More than half of all Supreme Court hearings have been held within 16 days of the announcement of the nominee. This case is no different. A couple of examples. Justice Stevens, 10 days. Justice Rehnquist, 13 days. Justice Powell, 13 days. Justice Blackmun, 15 days. Justice Berger, 13 days. These right along in the same kind of process that has historically been the process of the Senate. So then the argument is made that, well, this is an election year, and the Republicans said back in 2016 that in an election year they wouldn't move forward with then President Obama's nomination. What are the facts? A vacancy has arisen in a presidential election year 29 times. Every single one, and this is important to note, every single one of those 29 times, whoever was the sitting president made a nomination to replace the vacancy, to fill the vacancy. Every one of those 29 times. 19 of those 29 times, the parties of the president and the Senate majority were the same. And 17 of those 19 nominees were confirmed. By contrast, of the 10 times in which the Senate was controlled by the party opposite to the president, only one time did the Senate that was not of the party of the president proceed to fill that vacancy. In fact, vacancies under a divided government, meaning a Senate and a presidency from different parties, have not been filled for over 130 years, going back to 1888. So much like when the Senate exercised its constitutional right, fully consistent with precedent in 2016, not to fill the vacancy when there was divided government, the Senate is today exercising its duty to move forward with processing this nomination, just like the vast majority of Senates in the past have done every time this has happened. And it's important to note that. Any claim that this process is unusual or that it violates the clear precedent of the Senate is simply false. So then, back to the attacks on the members of this committee on the Republican side, and frankly against the president. It says that we're trying to engage in court packing. Now, that's a novel one because it's actually the Senate following standard procedure with regard to a vacancy that is now being accused of being court packing, when my colleagues on the other side are actually proposing court packing. That is, to statutorily and with the signature of a president, change the law so that they can add more members to the court. FDR tried this, and his effort was rejected. That effort should be rejected now, but let's be clear about it. This is not court packing. That, threatening to pass a law and change the court, is court packing. So then what were the arguments that were actually leveled against Judge Barrett? Well, the standard arguments. She is going to overturn all protections for women. She is going to change all of the laws in the country that protect people's health care. And everyone in this country who has a pre-existing condition or has any kind of a worry about getting support needs to worry that she's going to be an activist judge and a justice and go in there and change the law. She's not, and we all know that. This is simply the tired, worn out argument that is constantly made every time a Republican president nominates a candidate for the bench for the Supreme Court of the United States. And it's never been true, and it will not be true with Judge Barrett. So then the attack is, well, the Republicans don't care about people's health. They won't even try to get COVID relief out. And we're here in a hearing in the Judiciary Committee when we ought to be passing COVID relief legislation. And I've heard several of my colleagues basically say the Republicans are refusing to work on helping to address the COVID crisis. This coming from colleagues who just a month or so ago voted unanimously to filibuster a $500 to $600 billion COVID relief package in the Senate. A COVID relief package, I asked my staff to get me a quick summary of it, that put, as I indicated, somewhere between $500 and $600 billion into more small business loans, unemployment insurance, agriculture and farming assistance, postal service assistance, education assistance, both at the higher education levels and at K through 12, healthcare assistance for pandemic preparation, for strategic stockpiles, for testing, for contact tracing, billions for vaccine and therapeutic and diagnostic development, and the list goes on. We were stopped from proceeding with this legislation by a filibuster of those who now accuse us of not wanting to try to do something. We stand ready if you'll simply let us go to the legislation and pass it. So now, Judge Barrett, let me talk about you. Judge, you have an exemplary academic record and legal credentials, and you are preeminently qualified to serve on our Supreme Court. Following your graduation from law school, you clerked for both the U.S. Court of Appeals for the District of Columbia and the U.S. Supreme Court. At the Supreme Court, you clerked, as everyone knows, for none other than the late Justice Antonin Scalia. Upon receiving your nomination to the Supreme Court, Judge Barrett reflected on her clerkship for Justice Scalia, citing his incalculable influence on her life. She also stated that his judicial philosophy is hers too, and that a judge must apply the law as written. That's what we need in our next Supreme Court justice. Rather than the activist justice that you are being accused of being. Judges are not policymakers, and they must be resolute in setting aside policy views that they may hold. And I know you know that. Should we not take Judge Barrett at her word? As a judge, Supreme Court or otherwise, she must be dedicated to interpreting the law as written with an unparalleled commitment to our Constitution. I've visited with her privately. I've reviewed her record. I have seen nothing that would indicate that she is not telling the truth when she says that is her view of how a judge should conduct herself. I've met with a number of Supreme Court nominees in my service in the Senate, and throughout I've continued to maintain an emphasis on following the law and upholding our Constitution, and that must be a central characteristic of the justices we select for this highly influential part of our government. Judges have a great responsibility to carefully exercise their authority within the limits of the law. Our court system has the responsibility to preserve our constitutional rights, ensure a limited government, and provide speedy and fair justice. Following her clerkships, Judge Barrett spent time in private practice before beginning her tenure as a professor. Her academic scholarship and lengthy analysis of issues facing the federal courts make her uniquely well qualified to serve on our nation's highest court. In particular, Judge Barrett's thoughtful exploration of the precedent and the doctrine of stare decisis demonstrates that she is both intellectual and deliberative in her understanding of the law. Moreover, it's evident that she understands the role of a fair and proper judge. In September 2017, Judge Amy Coney Barrett came before the Senate Judiciary Committee, this committee, after being nominated to the U.S. Circuit Court of Appeals for the Seventh Circuit. During that hearing, she repeatedly expressed her commitment to independent and unbiased decision-making. I was proud to support her confirmation to the Court of Appeals in both the committee and on the Senate floor. Judge Barrett's remarkable resume shows she is a pioneer in the legal field. She will be the fifth woman and the first mother of school-age children to serve on the Supreme Court. In many ways, she's the ideal candidate to fill this current vacancy. Mr. Chairman, I look forward to hearing more from the nominee about her experience and her judicial philosophy. The next few days will prove invaluable as we discuss with Judge Barrett at length the proper role of a judge in our legal system. I look forward to this hearing. Thank you, Mr. Chairman.
Thank you. I believe Senator Harris.
Can you hear me?
Yes, hello.
Hello?
We hear you.
This hearing has brought together more than 50 people to sit inside a room for hours. A closed door. Yes.
Just wait just 1 second. We don't see you.
Of course. You don't see me.
One, congratulations on being on the ticket. I hadn't told you that. There we go. All right.
Can you see me now?
Yeah, I can see you now, hear you loud and clear. The floor is yours.
Mr. Chairman, can you see me and hear me?
I see you. I hear you. The floor is yours.
Okay, I appreciate it. Thank you, Mr. Chairman. This hearing has brought together more than 50 people to sit inside of a closed-door room for hours while our nation is facing a deadly airborne virus. This committee has ignored common sense requests to keep people safe, including not requiring testing for all members, despite a coronavirus outbreak among senators of this very committee. By contrast, in response to this recent Senate outbreak, the leaders of Senate Republicans rightly postponed business on the Senate floor this week to protect the health and safety of senators and staff. Mr. Chairman, for the same reasons, this hearing should have been postponed. The decision to hold this hearing now is reckless and places facilities workers, janitorial staff, and congressional aides and Capitol Police at risk. Not to mention that while tens of millions of Americans are struggling to pay their bills, the Senate should be prioritizing coronavirus relief and providing financial support to those families. The American people need to have help to make rent or their mortgage payment. We should provide financial assistance to those who have lost their job and help parents put food on the table. Small businesses need help, as do the cities, towns, and hospitals that this crisis has pushed to the brink. The House bill would help families and small businesses get through this crisis. But Senate Republicans have not lifted a finger for 150 days, which is how long that bill has been here in the Senate, to move the bill. Yet, this committee is determined to rush a Supreme Court confirmation hearing through in just 16 days. Senate Republicans have made it crystal clear that rushing a Supreme Court nomination is more important than helping and supporting the American people who are suffering from a deadly pandemic and a devastating economic crisis. Their priorities are not the American people's priorities. But for the moment, Senate Republicans hold the majority in the Senate and determine the schedule. So here we are. The Constitution of the United States entrusts the Senate with the solemn duty to carefully consider nominations for lifetime appointments to the United States Supreme Court. Yet the Senate majority is rushing this process and jamming President Trump's nominee through the Senate while people are actually voting, just 22 days before the end of the election. More than 9 million Americans have already voted, and millions more will vote while this illegitimate committee process is underway. A clear majority of Americans want whomever wins this election to fill this seat, and my Republican colleagues know that. Yet they are deliberately defying the will of the people in their attempt to roll back the rights and protections provided under the Affordable Care Act. And let's remember, in 2017, President Trump and congressional Republicans repeatedly tried to get rid of the Affordable Care Act. But remember, people from all walks of life spoke out and demanded Republicans stop trying to take away the American people's health care. Republicans finally realized that the Affordable Care Act is too popular to repeal in Congress. So now they are trying to bypass the will of the voters and have the Supreme Court do their dirty work. That's why President Trump promised to only nominate judges who will get rid of the Affordable Care Act. This administration, with the support of Senate Republicans, will be in front of the Supreme Court on November 10th to argue that the entire Affordable Care Act should be struck down. That's in 29 days that that'll happen. And that's a big reason why Senate Republicans are rushing this process. They are trying to get a justice onto the court in time to ensure they can strip away the protections of the Affordable Care Act. And if they succeed, it will result in millions of people losing access to health care at the worst possible time, in the middle of a pandemic. 23 million Americans could lose their health insurance altogether. If they succeed, they will eliminate protections for 135 million Americans with pre-existing conditions like diabetes and asthma, heart disease, or cancer. A list that now will include over 7 million Americans who have contracted COVID-19. Insurance companies could deny you coverage or could sell you a plan that won't pay a dime toward treating anything related to your pre-existing condition. If the Affordable Care Act is struck down, you will have to once again pay for things like mammograms and cancer screenings and birth control. Seniors will pay more for prescription drugs, and young adults will be kicked off of their parents' plans. And these are not abstract issues. We need to be clear about how overturning the Affordable Care Act will impact the people we all represent. For example, Micah, who is 11 years old and she lives in Southern California. So Micah enjoys being a Girl Scout and ice skating and reading and eating pasta and baking. Her mother says the only reason Micah is able to live her life as she does now is because the Affordable Care Act guarantees that her health insurance cannot deny her coverage or limit her care because it's too expensive. You see, Micah has a congenital heart defect. She goes to multiple specialists throughout the year and gets an MRI with anesthesia every 6 months. At just 11 months old, Micah's family had already hit $50,000 in medical expenses, and her biannual MRI cost were $15,000. By 11 months old, her family had hit $500,000 in medical expenses. If Republicans succeed in striking down the Affordable Care Act, insurance companies will be able to deny coverage for children with serious conditions. Children like Micah. And parents, well, they'll be on their own. No one should face financial ruin to get their child or their spouse or their parent the care they need. And no family should be kept from seeing a doctor or getting treatment because an insurance company says that the treatment is too expensive. In America, access to healthcare should not be determined based on how much money you have. Healthcare and access to healthcare should be a right. Micah and millions of others who are protected by the Affordable Care Act know this is fundamentally what is at stake with this Supreme Court nomination. And of course, there's more at stake. Throughout our history, Americans have brought cases to the United States Supreme Court in our ongoing fight for civil rights, human rights, and equal justice. Decisions like Brown versus Board of Education, which opened up educational opportunities for Black boys and girls. Roe versus Wade, which recognized a woman's right to control her own body. Loving v. Virginia and Obergefell v. Hodges, which recognized that love is love and that marriage equality is the law of the land. The United States Supreme Court is often the last refuge for equal justice when our constitutional rights are being violated. Justice Ruth Bader Ginsburg devoted her life to fight for equal justice, and she defended the Constitution. She advocated for human rights and equality. She stood up for the rights of women. She protected workers. She fought for the rights of consumers against big corporations. She supported LGBTQ rights, and she did so much more. But now, her legacy and the rights she fought so hard to protect are in jeopardy. By replacing Justice Ruth Bader Ginsburg with someone who will undo her legacy, President Trump is attempting to roll back Americans' rights for decades to come. Every American must understand that with this nomination, equal justice under law is at stake. Our voting rights are at stake. Workers' rights are at stake. Consumer rights are at stake. The right to a safe and legal abortion is at stake. And holding corporations accountable is at stake. And again, there's so much more. So, Mr. Chairman, I do believe this hearing is a clear attempt to jam through a Supreme Court nominee who will take healthcare away from millions of people during a deadly pandemic that has already killed more than 214,000 Americans. I believe we must listen to our constituents and protect their access to healthcare and wait to confirm a new Supreme Court justice until after Americans decide who they want in the White House. Thank you.
Thanks, Senator Harris. Senator Kennedy.
You have a beautiful family, Judge. We claim you in Louisiana. We're proud of the fact in Louisiana that you were born in Metairie, a suburb of New Orleans. We're proud of the fact that you got a solid education at St. Mary's Dominican High School. Come back and visit us. I know your mom and dad still live there, and we're very proud of you and your career. This is a solemn occasion, as it should be. I can't think of another position, at least not a position that is for life, not a position in which the occupant is not elected by the people, that is more powerful, at least not in the Western world, than an Associate Justice of the Supreme Court. And this process is not supposed to be the big rock candy mountain. Our job is to advise and consent. And that's one way of saying that we're supposed to make sure that the president hasn't, whatever president makes the nomination, hasn't made a mistake. And we all, as you can see, take that job seriously, as you can see, and we know you respect that. That's why I think over the next several days, it's appropriate for us to talk about your intellect, which is obvious, by the way, and your temperament, your character, and your judicial philosophy. And I hope we can talk about something else. And that's the role of the federal judiciary in American life. Now, look, Judge, I'm not naive. I understand this thing can turn sour real fast. We all watched the hearings for Justice Kavanaugh. It was a freak show. It looked like the cantina bar scene out of Star Wars. And I know, for someone unaccustomed to it, that it hurts to be called a racist. I think it's one of the worst things you can call an American. I know that it hurts to be called a white colonialist. And I know it must hurt for someone of deep Christian faith like yourself to be called a religious bigot. And to have it implied that because you are a devout Christian, that you're somehow unfit for public service. Before it's over with, they may call you Rosemary's Baby, for all I know. I hope not. And I know, as we've seen this morning, I know you think it's unfair. It is unfair for my colleagues to suggest, some overtly, some more indirectly, that if you're put on the United States Supreme Court, you will be on a mission from God to deny health care coverage for pre-existing conditions for every American. I know that seems preposterous to you, and it seems that way because it is. Take comfort in the fact that the American people, some of my colleagues disagree with this statement. They believe in government. I believe in people. The American people are not morons. They can see drivel when they see it, and they can appreciate it when they see it for being what it is. Now, let me turn to what I hope quickly we can talk about today. Americans love democracy. We'll even fight for it, and we have. And that's a wonderful thing. It's an important thing in today's world as this world becomes more authoritarian. And our founders, but we don't have a pure democracy. As a columnist I read this morning said, when we have to decide a complex issue dealing with social norms or economic issues, we don't all put on a toga and go down to the forum and vote. We have elected representatives. Those are members of Congress. And it is our elected representatives' job to decide social and economic policy. And if we don't like what they do, they're accountable. We vote them out. But in the last 50 years, certainly in the last 25, the United States Congress, either voluntarily or involuntarily, has ceded a lot of its power to the executive branch and to the federal judiciary. When I say the executive branch, I'm not necessarily talking about the president. I'm talking about the administrative state, the bureaucracy, as some call it. It's this giant rogue beast that enjoys power now that only kings once enjoyed. Members of the administrative state write their own laws. They interpret their own laws. They litigate their own courts before judges that they appoint. And Congress has allowed that to happen. I think Congress has also abdicated a lot of power to the federal judiciary. I do. And I'm not saying that federal judges don't make law. Of course they make law. They make law in the context of a specific case. It's called judicial precedent. But our founders intended federal judges to exercise judicial restraint and to understand the special role, scope, and mission of the federal judiciary vis-a-vis the United States Congress. I don't think our founders